Welcome to American Common Sense, a fun look at the state of American politics, inspired by Thomas Paine's Common Sense from 1776, hosted by James Humphreys. Welcome back to another episode. As always, I like to start with a quote from George Washington. Today's quote: "A primary object should be the education of our youth in the science of government. In a republic, what species of knowledge can be equally important? And what duty more pressing than communicating it to those who are to be the future guardians of the liberties of our country?" I thought of that quote in particular because of the subject we're going to talk today. For the first time in my lifetime, certainly in my political life over the last 30 years, we face the beginning of an actual constitutional crisis here in the United States. How far it will go, or if we are able to back away from it, is yet to be determined. We are right at the very beginning of a real challenge between the executive branch and the judiciary. The challenge, of course, is all about what's happening with illegal immigration, which is one of the biggest reasons that President Trump was reelected to a second term in the 2024 election, and how we're going about doing things. And as I've said before to all of you, I believe there's a right and wrong way to do this. It's not just about the ends, it's about the means and how we accomplish them. I'm not very Machiavellian, unfortunately. In March of 2025, the president began deporting people from all walks of life who were here illegally, some of whom were here legally, and then he removed their legal status. There are multiple ways to do so, and most of it was not controversial, questionable, but politically it was, that's always an issue, but it was legal in every way, until we get to a spot where the executive branch wanted to remove a number of people without using due process. And they used a 1798 law called the Alien Enemies Act. And when they ran that Alien Enemies Act, they said they were going to use it. They rounded up a bunch of people. They said a certain gang from Venezuela was too tied to a criminal organization with the government, and therefore they could use that act and they could deport them, or just pick them up and just deport them immediately. And they ran a couple of flights to do so. A number of people went to court immediately while this was happening and asked a federal judge, to stay that process while they decided whether this was going to be legal or not legal. And while that court hearing was happening, the flights that they were dealing with took off. Instead of flying to Venezuela, they flew to El Salvador, and the United States has a contract with the El Salvadorian government and to house some of these people, and they were taken down. The judge in this case issued an order before the planes touched down, after they'd taken off and before they touched down, that said you have to bring these people to court, that they're entitled to due process based on the 5th and 14th Amendment of the U.S. Constitution, and we have to have the government provide evidence that this is the case. The flights didn't do so. They touched down where they were at. The judge specifically said in his oral order that if there were planes in the air, they had to be turned around and brought back to the United States, so that those people could be afforded due process while he was looking over the temporary request to see if there was an issue or not an issue. After the people were deplaned and put in prison, they had left American soil, and the judge asked for a series of questions as to what was going on, when this happened, the timing of when this happened, when they left U.S. airspace, etc., trying to determine whether or not his order had been deliberately violated. And the Justice Department began stonewalling. They stonewalled in the sense they said, we're not going to answer these questions. And then they said, we're going to answer these ones, but not these ones because there's national security issues. And then the judge said, well, we'll do it in secrecy so that there's some Latin terms that you don't need to know, but that no one except me and you know what's happening. It'll be quiet behind the scenes and I can make a determination. And the Justice Department again refused to do so. And then the judge extended the stay. They appealed the judge's temporary restraining order to the full court. The court, the D.C. Appellate Court, agreed with the judge to begin with, and that's where we're at. That's a really generic way of looking at it. I want to be kind of specific about it. The judge in this case is Judge Bozeman, James Bozeman, and the challenge is this. This judge was appointed by George W. Bush in 2002. I think it was. Yeah, George H.W. Bush. George W. Bush in 2002. He was moved to the federal appeals court from the district court in D.C. in 2011 by President Obama. And during the time that he served on the D.C. court, he also ran the FISA court, the United States Foreign Intelligence Services Court, from May of 2014 to May of 2021. And he also served as the presiding judge for the United States Foreign Intelligence Surveillance Court. So even compared to a number of Supreme Court justices, this judge is uniquely qualified to hear these specific cases. So politically going after him, as the executive branch has done over the last few weeks, is untenable because he's uniquely qualified in a way that works. And the DC district, he's also the chief judge of that district at this point in time. And so it's kind of hard to see why the executive branch and the judicial branch are fighting over this information at this point in time. One of the things that the executive branch has asserted is that once the planes left U.S. airspace, the judge's authority was no longer valid. Unfortunately, and I'm not sure why the Justice Department made this argument, they have to know way more than I do, but that's complete and utter garbage, because the planes that they were on were flagged U.S. aircraft, so that was U.S. soil. The people on those planes were still on U.S. soil until the moment they were deplaned in either Guatemala or El Salvador when they first got to where they were going. And so the judge's order should have been adhered to. It would have been better for the executive branch to avoid this entire confrontation if they'd simply said, we screwed up, we know we screwed up, we apologize, we're following your order at this point in time, which they're doing. The executive branch is following that order right now to the letter perfectly. They're a little annoyed with it, but they're doing it. And we could have avoided this entire thing. What has happened, however, though, is Judge Bozeman has been walking them down the line in order to find a way to hold them in contempt of court, which is one of the only times a judge has the ability to do something extrajudicial without a prosecutor to begin with. And the problem with that is this. There are two types of contempt. The first is civil contempt, where you would fine them for doing something you don't want to do. And the second is criminal contempt. Well, if you use civil contempt, you're going to fine them. They're the prosecutors who, for the Justice Department, who are representing the executive branch, well, they're going to be paying for that with tax dollars, which doesn't make sense. And if you try to hold them in criminal contempt, there are two challenges. The first is those that are defending the executive branch in court right now are not the ones signing the order. Most of the material that's been submitted by the government to the Judiciary for review, for the judge to review, have been actually signed by the Attorney General herself. So what's the judge going to do? Order the arrest of the attorneys from the Justice Department who haven't signed the paperwork that's been submitted? Or is he going to order the arrest of the Attorney General? Who's going to affect those arrests if he does that? And then we have the question of, just like we did with President Trump in his own trials prior to the election, what immunities do these folks serve while serving in their official capacities for the United States? All of these questions create some serious challenges that would have to be litigated all the way to the Supreme Court. And that would leave the executive branch likely unable to use the Alien Enemies Act to continue to push out those that they want to violate their due process. And I say violate due process because while that act in 1798 was questionable, signed by John Adams lost re-election after one term to Thomas Jefferson almost entirely because of the Alien and Sedition Acts, which everyone knew were unconstitutional, but were never officially challenged in the courts. However, in the United States, everything is last in, first out. A law written today supersedes any law written earlier if there's a conflict. That's almost always the case. And so beginning in 1904, the Supreme Court began holding, over the course of 6 different Supreme Court cases from 1904 to 1976, that people who came to the United States legally at first and then illegally as of a Supreme Court case in 1953 are allowed certain privileges of the Constitution because they're subject to the United States laws and they're subject to due process. Judge Bozeman did not say, I want to stop these people from being deported. He said, you have to prove that they're members of this gang in order for that act to apply, and they were not given the opportunity to present evidence whether they were or were not by either the government or the defendants themselves who were going to be deported. And since the Supreme Court has multiple precedents that say everyone, including illegal immigrants, has a right to due process in the United States if you're on U.S. soil, we have to afford them that opportunity. So there's a right way and wrong way to do this. Whether these people are or not members of this gang, whether they're subject to the Alien Enemies Act or not, is questionable. I will tell you this, the Alien Enemies Act, however, has one problem. And that is, reading right from the act itself, Section 1 of an act respecting alien enemies, it says, be it enacted by the Senate and the House of Representatives of the United States of America in Congress assembled, that whatever there shall be a declared war between the United States and any foreign nation or government, or any invasion or predatory incursion shall be perpetrated, attempted, or threatened against the territory of the United States by any foreign nation or government, and the President of the United States shall make a public proclamation of the event, they have a right to deport them. A criminal gang from Venezuela is not a declared war, and even if we think it's an incursion, it's not an invasion or incursion by a nation itself. So I'm not sure this act works the way they want to. The very first one of these, an act about aliens themselves, may work, but this act doesn't work. And so it will work its way through the courts like it's supposed to. But right now we're dealing with, now that we have people who have been deported without due process that are on foreign territory, can the U.S. court system order their return? Does the executive branch have to listen in that situation? Was the judge's order ignored, and what punishment or lack of punishment would be incurred as a result of violating a judiciary order? Does that order matter? Will or will it not be upheld by the Supreme Court of the United States? All of these are hard questions that create a situation where the executive branch and the judicial branch will be at loggerheads in all likelihood for a couple of years while this situation works its way through the courts. I realize I sound like a professor today and it's a lot to manage. What matters most here is process. The United States is a country that is run by the rule of law. We must obey that law. We have to remember the legislative branch writes the law, the executive branch enforces the law, and the judiciary interprets the law when there is a conflict between the two. The legislative branch, once again, is choosing to sit on the sidelines and not make an opinion about whether or not they should or should not get involved, whether or not their power has been usurped by the executive, or whether they believe it's been interpreted correctly by the executive. So the legislative branch is sitting on the sidelines, not doing anything of value here. The executive branch is being stubborn in its resistance, and the judiciary is being stubborn in its constitutional powers to review the law as written. That kind of butt is not something we see very often in our government. How it will play out is anyone's guess. I would love to hear in the comments below your opinions as to whether or not you think this is constitutional. Not whether or not you agree that we should do this. Everyone agrees that people who are criminals should be removed from the United States. We have to prove they're criminals. Do we think the executive branch did enough to do that, or do we think they didn't? Do we think the legislative branch should get involved and adjust the Alien Enemies Act to accommodate what the president is attempting to do, or to reinforce their authority to say it is up to us to make this determination? In what way is the judiciary doing its job? Is it doing too much? Is it being too aggressive? Do you believe that it's doing exactly what it's supposed to do? I would love to see a robust conversation about that in the comments below, and hear from each of you via email or on Facebook or Instagram on these things as well. I hope this has been helpful. I know it's a lot of information, but this is one of the most important issues of our time. We can't let emotion get involved here. We have to let our heads and reason rule the day as we determine whether or not we're going to remain a country that lives by the rule of law. I appreciate your time, and we'll see you in the next one.